Hey everybody, I'm Damon Moore, and I want to welcome you to my behind the scenes video. It's a presentation for the checklist. I'm testing out some equipment and some other things, and so I thought one of the best ways for me to do that would be to put together this presentation, and so this gives you an opportunity to see me putting the presentation together in a very rough form. Before I launch into these 50 uh, uh, relationship breakup tips, I've got to give you a bit of a disclaimer. I'm a lawyer and a mediator, but I'm not your lawyer or mediator yet. Once you sign an agreement, then I'll be your lawyer or I'll be your mediator, and I'll be happy to help you. And until then, kind of think of this information to be a guide and not something that establishes an attorney-client or mediator-client relationship. The tips that are contained in this presentation should be used as a reference work only. As always, you should seek the counsel of a competent lawyer in order to help you determine whether you have any issues that are not addressed in this presentation. So the list of tips here, they're not exhaustive. I'm going to go through 50, but there are many more. These are just some of the things that I've found to be useful as a result of being able to interact with hundreds of clients, either in the mediation space or in the litigation space. For many people, a breakup or a divorce is a difficult and emotionally draining experience. One of the things that you can do to make a relationship or a breakup more difficult is when you come into that breakup unprepared. If you go into the breakup unprepared, then the emotional and the financial and the other legal challenges that are associated with the breakup, they may cause you to make mistakes that will have a negative impact on your future. This presentation is meant to give you a guide, some things that you can consider so that you'll be more prepared for the challenges that you're going to face once you filed for divorce or otherwise uncoupled yourself. This presentation is intended to provide a checklist that you can use as you plan the next several months or years of your life. The checklist should be useful to you, whether you represent yourself or you hire an attorney to assist you. And for me, I would love to have the opportunity to be able to work with you, but you're welcome to use this information to represent yourself. I'm not holding back any information. So I just wanted to let you know that up front. Also, on a personal note, I've been representing clients in family law or domestic relations matters since 2005. Since 2011, I've also served as a mediator, helping ex-couples resolve their disputes outside the courtroom. I've learned a lot from those experiences, and the 50 tips that you're about to hear are a product of that experience. And from time to time, I may kind of stop or go off script to talk about some things that I think are particularly important. Those are things that you may not read if you have chosen to download the ebook version of this. And if you want the ebook, then just reach out to me and let me know, and I'll be happy to send it to you. I'll provide my contact information after or at the end of this presentation. So number 50, revoke any power of attorney. If you've executed a power of attorney that gives your spouse or the person you're dating the right to handle financial or business affairs on your behalf, then you should revoke that power of attorney in writing. The process of creating or revoking a power of attorney may be different from state to state. So I'm licensed in Texas, Georgia, Indiana, and about 9 other states. And the process is certainly different in those states. So you're going to want to check within your own state and make sure that you understand that what that process is if you're representing yourself. Number 49, consider changing your will. You should consider changing your will if your spouse is named in it. However, it's important to keep in mind that you may not be able to completely cut ties to your spouse during your marriage. In some states, your spouse may be entitled to a share of your estate if you die while you're married to him or her, even if you've already started the divorce proceedings. Number 48, sanitize your social media accounts. And this one is an important one. When I'm deciding whether I want to take on a case, a lot of times what I'll do is I'll look at each party's social media accounts. I'm usually looking for a handful of things: photos or videos of either party with someone of the opposite sex, a post, video, photo, etc., that either indicates or implies that one of you has had an adulterous relationship, any references to drinking alcohol, using drugs, or engaging in questionable or illegal activities, any reference to or any references to drinking alcohol. Anything that shows you or your spouse approving of behavior that is immoral, illegal, or questionable, such as a Facebook like of someone using drugs. I might be looking for anything that can be used to show that you or your spouse shows poor judgment. I might be looking for posts, photos, or videos that support the notion that either you or your spouse is unstable or not adequately taking care of mental health concerns. And so if I'm looking for those things, and it's likely that the opposing party is looking for those things as well. So you should avoid posting those kinds of things in the future. And if you've already posted the things that I mentioned above or before, then you may need to carefully think about how you want to handle that fact. And some lawyers will advise you to go through your social media and delete the things I mentioned. Other lawyers will say deleting things from your social media account, especially after someone has filed a divorce petition, may constitute something they call spoliation of evidence. And in many courts, the intentional destruction of evidence could create a presumption that the evidence was unfavorable to the person who destroyed it. And so you have to be really careful about how you take that on, and that's something that you would be wise to speak to an attorney about before you actually begin to take those steps. But the main point here is that you want to sanitize your social media accounts, and if litigation has not started, then you absolutely want to sanitize those accounts. Number 47, make up your mind. Many people go into the divorce process without a real sense of certainty that they want a divorce. Even after filing for a divorce, some of my clients have changed their minds and decided to try to work things out. If you have doubts about whether you should go through with the divorce, then you should talk to your spouse or a counselor and attempt to clarify things for yourself. You will not be able to make decisions that are in your best interest during the divorce if you're not sure that you actually want one. Number 46, be ready or get ready to deal with your emotions. When it comes to getting organized and preparing a strategy that will help you get through the legal aspects of your divorce, your emotions can be a major hurdle if you let them. The opposing party may lie to the judge. Your lawyer, if you hire one, may hit you with a high fee for representing you in court. You may have to read documents that you don't understand. You may be forced to consider the possibility of losing a significant portion of your assets, your paycheck, or time with your children. And these threats to your way of life may cause you to feel confused, hurt, angry, depressed, any number of other feelings. But these emotions will only make things more difficult for you. So you have to be ready to deal with them. One of the best ways to deal with your emotions is to understand that emotions are a natural part of the process of going through a relationship breakup. Some choose to hire a licensed health professional to talk to when the emotions of the situation become particularly challenging. 45, consider your alternative dispute resolution options. Not everyone has to resolve his or her case through a contested trial in front of a judge. In many jurisdictions, there are alternatives to a contested trial that could save you time, money, and stress. One example of these alternatives is mediation. Mediation is the name given to a process in which parties meet with someone, a mediator, who acts as a neutral third party. The mediator helps the parties consider settlement options and encourages the parties to reach an agreement that fits their individual needs. In some states, mediation is mandatory if one of the parties requests it. Or a collaborative law divorce. In a collaborative divorce, each spouse has an attorney. The parties may also pay for a financial planner and a professional counselor to assist with child custody matters. The parties agree to resolve the dispute or the issues outside of court. They also agree to communicate honestly with each other about their financial matters and other relevant facts. Finally, they agree to disqualify their attorneys from further representation if the matter goes to trial. The collaborative law divorce may be the least stressful way to resolve a divorce. However, it can be a challenging process if the parties are not open and honest with each other throughout the process. Number 44, assume spying. As you know, we live in an electronic age. It's possible to purchase technology that will monitor a person's behavior. A person's incentives for purchasing this kind of technology, those incentives are high. And proof that someone is abusive or involved in adultery or engaged in other immoral behavior can heavily influence a judge in a custody case or a property distribution case. And I can tell you from my time as an attorney, this is one of the areas that people will use in these contested, divorces or breakups. I think the other more common tactic is to allege some kind of cruelty or physical abuse in a relationship. So, this is certainly an area where I see a lot of action in court. Number 43, be patient. In many divorce or custody battles, there's this moment when a client says, I just want to get this over with. Feeling that way is normal. However, making decisions based on a desire to get it over with will lead you to make concessions that you should not make. You do not have to rush things. You can afford to slow down. Please note that there are times when I advise a client to move quickly, but those situations occur when there's a strategic advantage to moving quickly. What I'm warning you about is the danger of moving quickly solely out of the desire to move on with your life. 42, figure out what you really want. You should figure out what it is that you really want. And once you know what you really want, it will be a lot easier for you to determine the strategy that you need to use in your case. It will also be easier to participate in negotiations with your ex or soon to be ex. Number 41, keep a diary. You should keep a diary because there's so much going on with your life, and I think it will be difficult for you to recall the details of things months into the future. So you have to start writing things down. Please note that there are some lawyers who will tell you not to keep a diary because they're concerned that the opposing party might request the diary as part of a discovery request. These lawyers are right to be concerned. In order to help decrease the likelihood that your diary will be used against you, I'd suggest that you avoid making negative remarks about your spouse and children in your diary. You should also avoid talking about your misdeeds in your diary. This diary is something that you should think of as a recording device for events, not as a device for you to express your thoughts or feelings about those events. Number 40, take pictures of your property. You should take pictures of your property. You can easily use the camera on your phone, or you can use something more complex. Whatever you use, you should take pictures of everything you own. In a divorce, taking pictures will help you create an inventory list if you're no longer living in the house at the time that the inventory list is requested. When you're doing your divorce, property distribution is one of the more important parts of the divorce. And if you're not in the house, then sometimes you may forget, what things you have. Now, if you're doing a breakup and it's not a divorce, but you've got some things in the home, and he or she has some things in the home, you want to be able to log what those things are so that it's easier to resolve disputes. I have a client that I'm helping on a do-it-yourself coaching matter in Austin and in Austin, Texas. And one of the things that is in dispute is a bed and who gets to keep the bed. And right now she has the bed and he wants the bed, but and he's saying that he made the bed for himself and not for her. And she won't let him into the house and won't let the police into the house. And it's a real mess. And, being able to have that inventory can help when you decide to go into court on that issue. Number 39, run a credit check. It is important that you figure out where things stand with your credit. So you should run a credit check. The names and contact information for the 3 credit bureaus can be found pretty easily. The names and the addresses are in my ebook, but you can also do a search through the internet and find those. It's TransUnion, Equifax, and Experian. So you definitely want to run a credit check. That will help you get a sense for whether there's some things that are going on that you are unaware of. Number 38, change your passwords. You should change your passwords on all your online services. You want to make sure that your ex is not accessing your accounts so that he or she can use the information against you. In the ebook, I've got a list of account passwords that many people involved in a breakup should reset. I'll tell you a few here in this behind the scenes video. Bank website and ATM numbers, credit cards, airlines, streaming video accounts, medical chart websites, computer backup services. Those are all things. Mobile phone accounts. Those are all things that I think are important to address. Number 37, obtain a copy of your original tax returns. You should obtain a copy of the most recent tax return that was filed with the IRS. You should obtain that copy from the IRS, not from your soon-to-be ex, and not from your file at the house. The IRS website states, if you need an exact copy of a previously filed and processed tax return and all attachments, including Form W-2, you should complete Form 4506, request for copy of tax return, and mail it to the address listed in the instructions, along with a $50 fee for each tax return requested. You may want to check and confirm on that fee. The dollar amount on fees are always changing, and so I'm saying 50 in this presentation. It could be more or less now, so that's something that you want to look into. Obtaining a copy from the IRS will help you make sure that you know it was filed. Number 36, gather your documents. Now is the time to gather your documents. Gather your bank statements, credit card statements, investment accounts, retirement accounts, mobile phone statements, utility statements, any kind of account. Once you have gathered your documents, you need to have an efficient way to keep track of them. If you choose to keep hard copies of those records, then consider purchasing one of those accordion style folders to use. And then, give the thing or give the folder some headings that you can use to put your information. Headings like household inventory, or income documents, or debts, children's expenses, evidence from witnesses, things of that type. You want to make sure that you're able to track that information and then store those statements in a safe place. Consider purchasing a safe if need be. You definitely want to keep those in a place where you can access them. Number 35, use a divorce divider spreadsheet. You should use a spreadsheet to help you with dividing your property if your breakup is a divorce. There are free applications that you can download which will help you divide the property. However, it's important that you know what kind of property division laws apply to your state, and whether you're in a community property state or some other kind of state. And you should make sure that the spreadsheet is set up with your state's system in mind. Number 34, read some court orders and decrees. Become familiar with what court orders and agreements look like. If you look at old folders or old orders and agreements, then you can use them as a guide to create your own order and agreement. If you'd like to see a sample agreement, then you're welcome to contact my office and ask for one. The court clerk's office in your local jurisdiction also often has sample forms for people to use. And if you have a county law library, then it's also common for the librarian to have access to useful sample forms. If your budget permits you to do so, you definitely want to speak with a lawyer to have that reviewed. One of the mistakes that I think people make is that they get these sample documents and then they assume that they can just make theirs just like that document they're looking at with just swapping out the names. And when you do that, sometimes you make mistakes and you fail to account for the possibility that those people did it wrong. Just because a judge signed off on a document does not mean that the document itself was correct when it was made. Sometimes things slip through the cracks, and you don't want that to happen with you. Just the other day, I was speaking with a client on a do-it-yourself matter. I'm providing some coaching, and then he's appearing in court on his own. And he was telling me that his old lawyer did not do any discovery, and that the opposing party didn't do any discovery on him. And And so nobody has exchanged any documents uh, where someone would be required to disclose property. And the spouse, or the other party in this case, has a retirement account with a couple of $100,000 in it. And the person that I'm assisting has no retirement account and has a bank account with about $2,000. Well, he's actually entitled to a portion of her retirement. But because his lawyer never asked for the information, and because the opposing party never sent out any requests, there's a chance that a document would go out for a judge to sign that doesn't indicate that she has any property that he's entitled to. And I'm certain that the opposing party did that on purpose. They figured, why should we ask for financial information that might make them ask us for financial information, and we don't want that. And this particular person, because his lawyer isn't or wasn't doing what he needed to do, that information isn't available. And if that document were to be filed and then someone else saw it and tried to use it for their own case, well, then they might miss out on an opportunity as well. So even if you get some documents that you're able to look at, you want to make sure that you have those documents reviewed by an attorney. I believe this is number 33, review educational materials. So there is a considerable amount of free educational material available for you to review. You can look at a website such as mine, damonmoore.com, or you can get on the internet and look at the same statutes and cases that a court will use to decide your case. The important thing is that you want to learn as much as about this process as you can learn before you have to have a hearing. I want to go off script a little bit here to say that this thing about reviewing educational materials is really important. I tell people who plan to represent themselves in cases that there's really three things that you have to be able to overcome to effectively represent yourself. You've got to understand the rules of civil procedure. How is it that I do certain things, and what are my deadlines, and things of that type. So the rules of civil procedure. You've got to understand the rules of evidence. How can I get my evidence in for the judge to consider? And how can I keep their evidence out? That's more or less what the rules of evidence is about. Getting yours in, keeping theirs out. So the decision is made in a way that presents you in the most positive light possible. And then the third thing that I think you have to overcome is just the anxiety that comes from discomfort with the system. Sometimes, when you show up at court, you don't know where you're going to go. Maybe the other side says something to you. They don't treat you with the kind of respect that you want to be treated with. How do you respond to that? What do you say? When you hear your own voice over the speaker while you're in the courtroom, just the anxiety of the moment. Those are things that you have to overcome to put yourself in the best situation to win, to get a positive result. And reviewing educational materials helps you increase your knowledge. And as you increase your knowledge, you become, more confident. And when you can review those materials and then you can appear in court and watch some hearings and see what works and what doesn't, then you're in a really good position to be able to present your case in a favorable way. Number 32, ask questions. When you go to the courtroom, you're placing your future in the hands of another person. You need to know what is going into the decisions that impact your life. If you're involved in a divorce, then you need to know what factors the judge considers when dividing the property. If you're involved in a custody dispute, you need to know what factors the judge considers before awarding custody. I can go on, but the bottom line is clear. You need to know what factors are involved in your case. Number 31, be strategic about giving your bottom line. In 2015, I was helping a business owner negotiate a land deal. Before we met with the opposing party, my client and I met and discussed the client's goals. I asked the client to tell me what his best offer was. He told me. The plan was we would go to the opposing party's lawyer's office and that I would lead the negotiation. But when we started the negotiation, my client led with his best offer. The opposing party accepted my client's offer. And for some time after that deal was made, my client was frustrated with the deal he made, even though the deal was one that he was willing to make because he felt like he could have gotten a better deal. You can keep that from happening to you by taking an incremental approach to your negotiation. As you move through the negotiation process, you'll be tempted to jump to your bottom line. But if you can resist that temptation, then you'll actually increase your chances of reaching a deal that works for you. If you jump to your bottom line and the opposing party accepts it, then you're always going to wonder whether you could have obtained a better deal. If you jump to your bottom line and the opposing party rejects it, then you're going to be tempted to create a new bottom line that will leave you even more disappointed. So the bottom line is that you want to be strategic about giving your bottom line. Number 30, plan your concessions. If your case is typical, then you're dealing with the divorce itself. So let's say if you're a typical divorce client or divorce party, then you're dealing with the divorce itself plus a combination of custody or conservatorship issues, visitation or possession and access issues, alimony or spousal maintenance issues, and property division issues. Depending on the category involved, you're going to want to start with a high number or a low number and work your way toward your opposing party's request. And the best way to deal with that reality is to plan out your concessions. Okay, I know I want every other weekend and 1 to 2 nights during the week of possession of the children, but I'm willing to give up, one of those weekends under the right circumstances, or I'm willing to give up one of those weekday nights under the right circumstances. Just know that when you go in, and the process will be a lot easier for you to resolve. Number 29, negotiate an agreement, not a concept. A lot of people make the following mistake. They start negotiating without a pre-drafted agreement. They go back and forth about what they might hypothetically do in certain categories. Then when they start drafting the agreement, they start negotiating again because they're seeing the agreement in writing for the first time. This wastes time and money, and it can frustrate both parties. You're better served by starting with a written agreement and negotiating off of that written agreement. Number 28, draft your proposed agreement. In order to avoid the scenario that I just talked about, you want to draft the agreement. When you draft the agreement, you should also draft the supporting documents that you need to complete, such as any inventories or visitation schedules. There are some lawyers who say they always want to be the one who controls the paperwork. If you think that's a good strategy, then be sure that you're the one who drafts the agreement. Number 27, clarity means more than legalese. A lot of people worry about creating documents that have legal language. The key is to write documents that clearly say what you want them to say. Clearly written documents are enforceable. Poorly written documents do not get enforced, no matter how many lawyer words they contain. Number 26, take your own debt. When you're drafting your own agreement, you should make sure that you have any debt in your name assigned to you. Why? You do not want to have to rely on your spouse to make those payments. Number 25, consider retirement plans and other benefits. Sometimes your spouse has retirement benefits and you don't know it. You want to make sure that you're always aware of your spouse's retirement benefits before you sign any agreement. And the discovery process is a really good way to make sure you know what it is that she has, and it puts her in a position to where if she doesn't disclose that information, if your spouse is a woman, if she doesn't disclose that information, then you've got the opportunity to go back into court later on because she didn't disclose it. And this is, the retirement benefits. A retirement benefit is something that a person can really get upset about, and sometimes can go to great length to try to keep from disclosing to you. So make sure that you're really on top of that. It looks like number 24. I had to pause for a second as I told you this is a behind the scenes video, and we're testing out some equipment. And for a moment, I thought that perhaps the volume on my microphone had gone out. And so it seems like everything is okay. So we're going to continue with number 24. Consider the taxes. You want to be sure that you're aware of the tax consequences of your property division. If you do not pay attention to this before the divorce is finalized, then you could get hit with a tax bill that could have been avoided or taken into consideration before the divorce. It's always a good idea to seek out the advice of an accountant or a tax expert. Number 23, let another person review your agreement. You should not be the only person who has reviewed your agreement or order. Show it to other people. You want to make sure that you show the documents to someone else so that you have a feel for whether the reader thinks the document says what you want it to say. Number 22, present the agreement to your spouse in a way that minimizes drama. You don't have to observe any particular formalities when you give the proposed agreement to your spouse. You do not have to deliver the proposed agreement through certified mail or anything like that. You just have to give it to him or her. However, you should give the document to your spouse in a way that minimizes drama. Number 21, gather feedback. After you have submitted your documents to the opposing party, you are going to receive feedback. Your spouse is likely to tell you what he or she does not like about the document. That's a normal part of the process. Sometimes that feedback is given to you immediately, and sometimes it's a few days or weeks that pass before you receive feedback. When the opposing party responds, he or she will probably object to several of your proposals. That's not a big deal. If you've planned properly, then you can give yourself some wiggle room in that proposed agreement. That will allow you to accept some of the opposing party's suggestions and still have an agreement that works for you. Number 20, schedule your negotiation meetings. Your negotiations will be more productive if you schedule them with the other person. If you plan an ambush negotiation, the other person is less likely to be prepared to discuss the matter, and he or she is more likely to back out of anything you try to get them to agree to do. So make appointments so that you can make sure that you're giving yourself the best chance to move toward an agreement. Number 19, consider negotiating the entire deal. A lot of lawyers will tell you that they negotiate as much of a deal as possible and then go to the judge to decide the matters that they can't be worked out. Other lawyers like to attempt to reach an agreement on the entire deal in an all or nothing fashion. I think you're better served by sending an entire proposed agreement. When you send the agreement, you can request feedback on the entire agreement at once. What I think you should avoid is something called piecemeal negotiating. An example of piecemeal negotiating is when you decide that you'll negotiate spousal maintenance. Then you negotiate child support. Then you negotiate child custody. Then you discuss other topics. One of the problems with negotiating piecemeal is that you end up focusing on every item. And that keeps you from prioritizing the issues in a way that you want to prioritize them. When you negotiate the entire package at once as a package deal, you can say, I give in on A, B, and C, but I need to have D. That approach can make you appear to be more reasonable. Number 18, keep an open mind. Do not become so attached to your offer that you cannot consider alternative agreements. If you send an offer that says your soon-to-be ex gets A, B, C, and D, then don't immediately shoot down a counteroffer that divides the property in a different way. If the other side has a counteroffer that permits you to achieve your goals, then you owe it to yourself to consider that offer. I'm going to go off script again for a moment here because this is an area in which clients of mine have faced challenges when they're thinking about something that, quite frankly, they shouldn't be thinking about, and that is using this deal to stick it to the other side. Sometimes a client or a party wants the other party to agree to something or wants to hit somebody over the head with some term because they know it'll hurt the person. And they'll kill a whole deal just because they can't get the person to give in on the thing that they want them to give in on, even though that thing isn't something that the client wants. That kind of situation happens a lot. So you want to really focus on keeping an open mind, remembering what your goals and what your objectives are, and whether the deal that's on the table helps you accomplish the things that matter to you. Number 17, create a property distribution system. There may be times when you will not be able to agree on how you should divide the property. If those times occur, then you should create a property distribution system. For example, the husband can pick the first item, the spouse can pick the second item. Number 16, ask more questions. As you go through the process, additional questions or concerns may arise. You can send me an email, or you can go to another website that may provide a question and answer format that's more useful to you. Number 15, educate, create, negotiate, edit. You'll want to educate yourself about the law and other factors that will play a role in your negotiation. Once you've sufficiently educated yourself, create the agreement and give it to your spouse. Then you start your negotiation. The agreement will quickly take on another form once your spouse returns the document to you. So be prepared to edit the document. The educate, create, negotiate, and edit cycle may repeat itself a few times. However, if you are prepared for this cycle to repeat itself, then you will be in a great position to bring the negotiation to a happy conclusion. Number 14, take breaks when necessary. Sometimes it's important to take a break so that you can clear your head. There's nothing wrong with taking some time off from the negotiation if taking time off helps you avoid making bad decisions. Number 13, use a notary. Once the two of you have reached an agreement, you should sign the agreement in front of a notary. Although in some instances, it may be more efficient for the two of you to sign the agreement in front of a notary at the same time, you don't have to do that. You can always have a document notarized at your bank. You can also have a document notarized at most law offices. I've seen people have documents notarized at the courthouse. There are a number of places where you can have it done, but it's very useful to do it. Number 12, tie up loose ends. You want to make sure that you have coordinated with third parties to have documents signed if that's necessary to finalize your agreement. So, for example, if you need to have someone sign off on retirement-related documents, then you should make sure that you have contacted that person. Same thing if you need to meet with a banker. Number 11, don't be afraid to go to court if necessary. Go to court if you must. If you can't make a deal, then do not be afraid to go to court. People represent themselves in court all the time. The two keys to representing yourself effectively are to understand the law at play in your situation and to not be intimidated by your lack of familiarity with how the court system works. And that goes back to what I was saying earlier. I think earlier I said it was three things, but I was just kind of splitting up the understand the law part into understanding the law of evidence and understanding the law of civil procedure. But in any event, those are the keys, and you should not be afraid to go to court if necessary. Number 10, use your county law library or courthouse. If you have to go to court and need forms, then you may be able to obtain the forms you need from your county law library or courthouse. At many courthouses, you can look at the case files in the clerk's office. Those files will contain pleadings that will give you an idea of the documents that might be filed in a case like yours. Number 9, don't worry about trying to sound like a lawyer. A lot of people who represent themselves in court attempt to imitate lawyers. You do not need to do that. Just sound like the best version of yourself. The judge knows you're not a lawyer. Trying to sound like one could cause you to lose your authenticity. Number 8, the court will hold you to the same standards as a lawyer. Although the judge knows that you're not a lawyer, the judge is supposed to hold you to the same standards as a lawyer. This is not as big a deal when both sides are representing themselves, but it can place you at a disadvantage if your spouse or the other party has a lawyer. In fact, I represented a father in a custody case that resulted in a 50-50 possession and access, also known as visitation, schedule, and no child support because the mother said some things that a lawyer would not have had her say. She represented herself, and it hurt her case because she did not understand the law and how the judge would view what she said. Now, in that instance, the person who did not have the lawyer lost her case. But I'll let you in on a little known secret. Many lawyers do not want to go against someone who is not represented by a lawyer. This is especially true when the case can be won or lost on the strength of the story, as opposed to cases that involve a lot of evidence and procedure. You may not be the best person to determine whether your case can be won on the strength of the story, as opposed to evidence and procedure. So you may want to speak with a lawyer about that issue, but it's certainly something that I have found to be the case in my time as an attorney. Number 7, get to know the courthouse clerk. The people at the courthouse who have the potential to help you the most are the courthouse clerks and court coordinators. You want to be as kind as possible to those people. You never know when the clerk or the coordinator might relay something about you to a judge. And even if they do not say something to the judge, they might give you some useful advice. Number 6, get the local rules. Each state has a set of statutes that set out the family law or domestic relations law in your state. And each state has cases that provide the way that a court has interpreted the state statutes. But each county is likely to have a set of local rules that define the way the courts in counties handle domestic relations cases. The local rules will tell you things that are unlikely that you're unlikely to see in any other document. For example, the local rules in Austin, Texas will tell you what day of the week you can be heard on a particular type of case. Number 5, beware of the most dangerous form of discovery, requests for admissions. There's a special type of document that the opposing party might file during the discovery phase in your case. The document is called the request for admissions. The document usually requires you to respond to it within a certain number of days. Do not respond to the request in a timely manner. Your failure to do so can be used against you. Number 4, cross-examination is not required. If you have to go to trial, you're not required to cross-examine the opposing party's witnesses. Sometimes people think they have to ask a witness something, and that can lead to the witness giving information that is not helpful. If you have nothing useful to ask, then tell the judge you have no questions for the witness. Number 3, always be ready and willing to settle if the terms are right. It is hard to predict when a case will settle, but one moment when a case is ripe for settlement is in the days leading up to the hearing. So be prepared to settle. Being prepared means having a document prepared that will enable you to reach an agreement soon after you have been informed that an agreement is possible. You do not want to fall into a situation in which the person says he or she wants to do a deal on terms that are favorable to you, but then the person changes his or her mind during the time it takes for you to try to create the paperwork. In some states, lawyers get around this scenario by drafting a short agreement and then reading that agreement into the record at a hearing. Then the lawyers create a longer document that's signed by the judge. Number 2, consider doing the divorce part of the divorce first. The divorce part of the divorce, in other words, actually ending the relationship for an at-fault or no-fault reason, is not that difficult. The challenge is doing all the parts related to the divorce. The property division, the child custody or conservatorship, visitation or possession and access, and dealing with third parties. So you might want to consider doing the hard parts of the process first. And number 1, celebrate. When you're finished, recognize that you have achieved something quite impressive. You should find time to celebrate your accomplishments. Some former couples will celebrate a breakup with a joint divorce party. Others have other ways of celebrating, but the important thing is that you look at the divorce as the start of a new phase in your life, and you treat it accordingly.